Swayam Prabha. Digital India. Educated India.
This is Dr. Saurabh Rana from Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal from Faculty of Law, University of Delhi, would be discussing the provisions of procedural criminal law contained in Bharatiya Nagrik Suraksha Sanhita 2023. In this session, we would be discussing provisions related to jurisdiction of criminal courts in inquiries and trials. So, we would be covering chapter 14 BNSS, which deals with jurisdiction of criminal court in inquiries and trial, and chapter 15, which deals with the conditions which are required for initiation of proceedings. Now, here when I say jurisdiction, it covers local jurisdiction or called territorial jurisdiction. So, there would be other jurisdiction also, other types of jurisdiction, we will talk about that later. When I say conditions here, it means conditions for taking cognizance. It is by taking cognizance of a criminal case that a criminal court initiates the proceedings. What is taking cognizance? We would discuss it later. Now, to start with chapter 14, which, as I said, relates to jurisdiction of criminal courts. Now, jurisdiction may be understood as territorial jurisdiction, as I said earlier. Jurisdiction may also be understood as a subject matter jurisdiction. Territorial jurisdiction is basically, it is where the crime is committed. So, you see, in ordinary cases, ordinary place of inquiry and trial is where, and by that court, within whose local jurisdiction it was committed, it as in the offence was committed. So, the basic idea of the territorial jurisdiction is that it would be that court which has territorial jurisdiction over the place where the crime was committed would be, trying that case. The other idea of jurisdiction is subject matter jurisdiction. Not only in criminal cases, but also in civil cases, we have general civil courts, which would be dealing with all the civil matters, and we have general criminal court, which would be dealing all the criminal matters, except in cases where the subject matter of a case has been assigned to a special court. So, for example, in civil cases, it may be a family court. An ordinary civil court would not be taking up the family matters, but it would only be a family court that would be taking family matters, as in divorce, etc. Special courts in criminal side, as I said, generally the crimes would be taken up by general criminal court, but if some special law creates a special court for a particular crime, so say for example, for SC/ST Act, if a case is registered under SC/ST Act, it would be SC/ST court that would be trying the case. Or say for example, PMLA Act. So, if a case is under PMLA, it would not be general criminal court that would be taking up PMLA cases, but it would be the special court known as PMLA court that would be taking up the PMLA cases. So, we discussed that there is something called territorial jurisdiction, there is something called subject matter jurisdiction. So, now that we know what is territorial jurisdiction and what is subject matter jurisdiction. Territorial jurisdiction means which court would have jurisdiction as in area wise. Subject matter jurisdiction is which court would be taking up the case as per the subject matter of the dispute wise. Now, here this chapter deals with territorial jurisdiction only, and as I said, the basic rule of territorial jurisdiction is that the offence shall be ordinarily tried by a court within whose local jurisdiction it was committed. So, if suppose a court is having jurisdiction in this area, an offence is committed here. So, if the court is denoted by A, this court would be taking up this case, not the case which has occurred or which the crime which has been committed outside the territorial jurisdiction of this court. Now, after this basic rule, we see that later provisions in this chapter would enlarge the area of territorial jurisdiction of a criminal court. So, basic rule is that the crime would be committed where the crime committed in a place would be tried by the court which has territorial jurisdiction over the place where it was committed, but then it is enlarged for practical reasons and for the sake of convenience by section 198 to 208, chapter 14, which we are discussing. So, let us see what are the provisions of enlargement of territorial jurisdiction. Now, in this context, section 190 BNSS says when it is uncertain in which of several local areas an offence was committed, then it says if that is the case, it may be inquired or tried by any court having jurisdiction over any of such local areas. So, there may be confusion. So, suppose this is the jurisdiction of court A, this is court B. Now, suppose a crime happens somewhere here and sometimes the boundaries are not so clear. So, there may be confusion, it may not be clear whether it happened in the territory of B or territory of A. If it is such a case, then section 198 says that this case may be tried by court A or court B. Either of them can try the case. Of course, one of them would be trying it. B says where an offence is committed partly in one local area and partly in another local area, then also it may be inquired by any court having jurisdiction over any such local area. It can be illustrated by saying that suppose this was court A local jurisdiction. Now, in this jurisdiction, X caused grievous hurt to Y and the violence continues into another court's territorial jurisdiction. Here, if you see, part of offence is committed in court A jurisdiction, part of this is committed say in court D's jurisdiction. Section 198 says that it may be tried either by A court or by D court. Next, it says where an offence is a continuing one and continues to be committed in more local areas than one. Again, any court having jurisdiction over any of such local areas may be trying that case. So, it would be illustrated as conspiracy is a continuing offence, and you see somebody sitting in Delhi, somebody sitting in Mumbai, somebody sitting in Madras or Chennai, they are conspirating with each other for commission of some crime, and it is continuing. So, this is something which is offence here is a continuing offence. It may be tried at any place, Delhi, Mumbai or Chennai. Or abduction, suppose. Abduction is again a continuing offence. So, if A is abducted, as in he was by use of force, he was made to move from place A to place B. So, suppose A is abducted from place say X, taken to place Y, taken to place Z and so on. Now, this is again a continuing offence which is happening at place X, at place Y, at place Z and may still be continuing further. Now, if this is the case, section 198 says that it may again be tried by any court over having jurisdiction over any such local area. So, the court at X, the court at Y or the court at Z may try this offence of abduction. Now, further clause D says where it consists of several acts done in different local areas, and of course, they all together constitute crime. It may be illustrated as, suppose A deceives B at place X, at place Y, at place Z, and then ultimately B yields to the deception and delivers a property to A. Now, this is an offence of cheating, and this would be comprising of all these acts where B was deceived and of course, where the property was delivered. All of them would together constitute the offence of cheating, and so this offence of cheating again may be tried at X or Y or Z or the place where the property was ultimately delivered. So, this was the first section which enlarges the territorial jurisdiction of a criminal court, over the basic rule that a crime is to be tried by that court which has territorial jurisdiction over the area where the crime was committed. Now, let us see another provision which again enlarges the territorial jurisdiction, section 199. It says offence may be tried by a court where act is done or by a court where consequence ensues. So, it says where an act is an offence by reason of anything which has been done, that is the act is done, and of a consequence which has ensued, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has ensued. So, it may be tried by any of the two courts. Its illustration can be that suppose A gives a defamatory statement against B at place X. Now, that defamatory statement was published in a newspaper at place Y. Now, you see the act was done at place X, the consequence ensued at place Y, and as per section 199, both courts, as in either of them, may try this case of defamation. Both of them would be having territorial jurisdiction over this case of defamation. Of course, one of them would be trying it. Now, the next provision in this context is section 200, which says that an act is an offence because it has a relation to an offence. So, here we are dealing with a crime, with a criminal act, which is crime because it is related to another crime. Now, for this situation, section 200 says that such crime, as in this crime, may be, so it says the first mentioned offence, as in this crime, may be inquired or tried by a court within whose local jurisdiction either act was done, either act as in this act or this act. Now, patent illustration of this provision is abatement of an offence. So, suppose an offence was committed at place X and it was abated at place Y. For this offence, of course, because for this offence it was committed at place X, so it would be tried at place X. But then this offence may be tried by, so the first mentioned offence, as in this offence of abatement, may be tried at any place where either act was, as in place X or place Y. Now, let us see section 201, which is concerned with certain offences. Earlier provisions were general, so they would be talking in terms of commission, etc., relation, etc. This section 201 is related to particular offences, as in dacoity, dacoity with murder, or belonging to a gang of dacoits, or escaping from custody. These are specific offences which are dealt with here, and it says the court within whose local jurisdiction the offence was committed or the accused person was found, either of them can try that offence. Clause 2 says, talks about kidnapping or abduction, and it says that any court within whose local jurisdiction the person was kidnapped or abducted or was conveyed or concealed or detained, etc., would be having territorial jurisdiction over such case of kidnapping or abduction. Again, provision 3 would speak about, again, specific offences, theft, extortion, robbery, and it says that such offences may be tried by a court within whose local jurisdiction the offence was committed, or the stolen property, which is the subject matter, is possessed by any person committing it, or by any person who received it knowing that it was a stolen property. So, again, where the offence was committed or the property was possessed by the person committing that offence or by any other person knowing that it was a stolen property, would be having territorial jurisdiction over these offences. Clause 4 says, in these cases, again it says, where the offence was committed or any part of the property which was the subject matter of the offence was received or retained or was required to be returned or accounted for by the accused person. All three of them would be having territorial jurisdiction. Either of them would be trying the case. Clause 5 says, any offence which includes possession of stolen property may be tried by where the offence was committed or the stolen property was possessed by any person who received or retained it knowing or having reason to believe that it was a stolen property. Either of them would be having the territorial jurisdiction, as in both of them would be having territorial jurisdiction, either of them would be trying the case. Section 202 is about offences committed by means of electronic communication, letters, etc. And it says, now clause 1 of section 202 says that if any offence which includes cheating, and it says that if deception is practiced by means of electronic communication or letters or telecommunication messages, it may be tried by, so it is a case of cheating where deception is caused in this manner or in this mode, it may be tried by any court within whose local jurisdiction such electronic communication letter messages were sent. So, from which place the communication was sent or were received, both would be having the territorial jurisdiction. And then it further says that if it is an offence of cheating and dishonestly inducing delivery of property, it may be tried by a court within whose local jurisdiction the property was delivered by the person deceived, of course, or was received by the accused person. So, if it was through some communication, it would be either court where from the communication was sent or where it is received, of course, by the victim. And if it is about inducing delivery of property, again it would be inquired or tried by any court where the property was delivered by the person deceived or it was received by the accused person. The next provision, clause 2, it talks about section 82. Section 82 is bigamy. Now, bigamy is when a husband or wife, while the spouse is, while the marriage is subsisting. So, if a husband or a wife, while his or her marriage is subsisting, he or she remarries. He or she remarries. That would be an offence of bigamy under section 82. Law says that such offence may be inquired or tried by a court within whose local jurisdiction the offence was committed, as in where the marriage was solemnized. So, place of solemnization of marriage would be where the offence was committed, or the offender last resided with his or her spouse by the first marriage, or the wife by the first marriage has taken up permanent residence after the commission of offence. Now, this is the ordinary place, as in section 197 says that where the offence is committed would be having territorial jurisdiction because the offence was committed here. Now, these are the extensions of this basic rule provided by section 202, and it is contemplating a situation, say for example, H and W, husband wife. Now, husband goes, so they say for example, they live in a state A, their matrimonial house is in state A. Now, H goes to state B, marries a woman while this marriage is subsisting and comes back with that woman to state A, that very house. Now, in that case, even the wife may go to another place, marry somebody and came back to that place. Now, if we look at this situation in ordinary parlance, then it would be only the place of commission, as in state B, any court that had territorial jurisdiction in state B, that would be having jurisdiction to try this case of bigamy. It would be very, very cumbersome. So, they would try to go as far as possible, as in husband or wife would try to go as far as possible, so that to make it very, very difficult for the other spouse to go there and file a case. So, for that purpose, the territorial jurisdiction has been enlarged, and it says where the offender last resided with his or her spouse by the first marriage. Offender means both, husband or wife, as the case may be. And then it says, or the wife by the first marriage has taken up permanent residence after the commission of the offence. This does not include husband. So, this provision is specially made for the females, as in the wives, who may go away from that house, as we were discussing, from that house in state A, may go away from there, may reside at some other place and would be, working there or something. So, this provision says that such wife, so if she goes to a place C, suppose, so after the husband commits bigamy, she leaves state A and goes to state C. In that case, she would be filing a case at place C also. Now, this provision, section 203, is about the crimes committed on a journey or voyage. So, for example, a running train, a running car, etc. And it says when an offence is committed while the person by or against whom or the thing in respect of which the offence is committed is in the course of performing a journey or voyage, then it says that such offence may be inquired or tried by any court through or into whose local jurisdiction that person or thing passed in the course of journey or voyage. This provision is self-explanatory, does not need any elaboration. Now, the next provision is section 204, which says that if any person commits offences, and these offences may be at different places. So, because they are committed at different places, as per the basic rule, section 197, which says commission gives territorial jurisdiction, so they may be tried at different places. This is wherever a particular offence is committed, it would be tried at the place of commission. But then this provision says, section 204, it says that if that is the situation, then if such offences may be tried at one trial for each of such offences by virtue of section 242, section 243 or section 244, they may be tried by any court competent to try any of the offences. So, if the offences are such, they are different offences, may be committed at different places. If they are such that they all may be tried at one trial by virtue of 240, 243 or 244, if they all may be tried at one trial, then they may be tried by any court competent to inquire or try any of the offences, So, suppose the places were like A, B and C, then in that case, any of the court would be having territorial jurisdiction A, B or C. Now, let us see what is the link which may combine them for a joint trial, as in section 242, 3 and 4, which is the prerequisite for application of this section 204. Now, when we look at section 242, it says if there are offences of same kind. So, offences of same kind committed at place A, B and C. So, if they are 3 in number, as in not exceeding 3, maybe 2 offences, maybe 3 offences, and they are committed within 12 months, then they may be tried at single trial, though there may be different transactions at different places, but still they may be tried at a single trial. And when this happens, that they may be tried at a single trial by virtue of section 242, section 204 additionally says that these offences may be tried by any court, as in our case it would be a court at A, B or C that would be trying this case. Now, let us look at section 243. Now, if we see section 243, it says that where in a single transaction, in 242 the transaction may be different, but here in 243 1, it is 243 1. It says if in a single transaction more offences than one are committed. So, if suppose in a transaction of robbery, A caused hurt, committed robbery, hurt to the victim, committed robbery. Now, in one transaction there are 2 offences. Section 243 1 says that they both may be tried at single trial. Single trial. Section 243 says if the act constitute an offence falling within 2 or more separate definitions, then also they may be tried at one single trial. So, act, so it is a bunch of acts falling within 2 or more definitions, same bunch of acts falling in 2 definitions. So, say for example, section 93 BNS says if father, mother or any person having care and custody of a child which is below 12 years abandons that child with an intention of wholly, leaving him or her, wholly abandoning him, then it would be an offence under section 93. Now, if suppose a person who was entrusted with care or was having care of a child under 12 years, he abandons a child in a desert. Now, his such acts would be falling under the definition of 2 offences. One would be section 93, as I said, as I mentioned here, and the other would be section 105, because the child dies. So, these 2 offences would be committed. Section 105 is culpable homicide not amounting to murder, because the person must have had the knowledge that the child would die in such circumstances. So, same bunch of acts falling under 2 separate definitions. Section 243 3 says that they may be tried at a single trial, and by virtue of 204 they may be tried by a single court. 243 4 says if several acts of which one or more than one would by itself or themselves constitute an offence, constitute when combined a different offence, the person accused of them may be tried at one trial for all such offences. So, again let us illustrate 243 4. Now, here the situation would be again the bunch of acts. So, say for example, it is hurt as we discussed and robbery. Now 243(4) says that if by permutation and combination, two or more than two offences may come out of this bunch of acts, then all such offences may be tried at one trial. So let us see this case. In this case, so A caused hurt to B and robbed him. In this case, he did two acts. If we take this act, it would be offence of hurt. If taken alone, would be punishable under section. Now, out of this bunch of acts, if we consider hurt, it would be an offence under section 115 of BNS. If we consider robbery, then again it would be an offence of robbery. Now, if we consider this act, that is robbery, this would be punishable under section 309 clause 4, and if we consider them both together, that would be falling under a separate provision, that is 309(6), that would be causing hurt while committing robbery. So, same bunch of acts falling in three definitions. When one act is taken, individual act is taken, hurt, another individual act, robbery, and if both are taken together, it is hurt while robbery. Section 243(4) says that is the situation, then they all may be tried at, as in these three offences, may be tried at one trial. And when they are tried at one trial, if we read section 204 along with section 243(4), they would all be tried by the court having territorial jurisdiction over any of them, hurt, robbery, or of course hurt while robbery. So, any of such court may try the cases. Section 244 says when it is doubtful what offence has been committed, then all such offences may be tried at one trial, and by virtue of section 204, any court competent to try any of such offences which are in doubt, as in which of them is committed, as in the illustration A says that if A is accused of an act which may amount to theft, which may amount to receiving stolen property or criminal breach of trust or cheating, he may be tried for all of them, as in alternatively either theft, stolen property, CBT or cheating, and may be charged and tried at a single trial. And by virtue of section 204, any court which is competent to try any of the offences would be holding that single trial. Then it says, clause B says, the offence or offences committed by several persons are such that they may be charged with and tried together by virtue of provision of section 246. Now, if we read section 246, it is apparent that whatever we have discussed for 242, 243 and 244, that was for a single accused. If there are more than one accused, then all of them may be tried at single trial. And in that case, any court competent to try any of such offences would be having territorial jurisdiction. So, the difference between 242, 243 and 244 on one hand and 246 at the other hand is that of the number of accused. That is the idea involved with section 246. that if the offence has been committed by more than one accused persons, then in the same spirit that we discussed 242, 243, 244, we may try all of them together at a single trial. Now, the next provision is section 205. It says it gives power to the state government that it may direct any case or class of cases which have been committed for trial in any district may be tried in any sessions division. The idea is that suppose this is a session division. You see, committed means committal to sessions judge. We will discuss it today, what the committal means. So, if a case is session triable, the magistrate would not be trying this case and would be sending it to session court for trial. This is called committal of a case to session court, and this provision says that if a case has already been committed for trial, as in the magistrate finding it to be session triable, and how would we find whether a case is session triable or not? We would look at the schedule 1 of BNSS and will come to know whether a particular section of BNS is tried by which court. So, say if a particular section is triable by session court, the magistrate would send it to the session court. This is called committal. So, if a case has been committed for trial in any district. Now, if we look at the sessions division, section 7(1) says that if it is a session division, it would be comprising of, it may be one district or it may be more than one districts. Section 7(1) says that it may comprise of one or more than districts. Now, this provision says that suppose this session division has 2 districts and the case has been committed. So, if the case is running in court B here in this district, court of judicial magistrate would be district wise, court of session judges would be session division wise. Now, if suppose a case from B district has been committed to this court of session, the state government may send it for trial to any other session division, that is, state government may send it to totally new another session division. Now, the next provision is section 206. Now, as we are discussing that after the enlargement provisions that we have seen from section 198 to 208, that would be, we are discussing now, that the territorial jurisdiction is enlarged and all of them would be having territorial jurisdiction. Now, what if 2 or more than 2 courts have taken cognizance of the same offence, as in that is also possible, as I said. So, if that is the situation, then the question as to who shall be continuing with the trial would be decided by the High Court if those courts are subordinate to the same High Court. And if they are not subordinate to the same High Court, then by the High Court which started the case first, as in where the case started earlier, where the proceedings were first commenced. So, where the case started earlier, that High Court would, High Court of that territorial jurisdiction would be having, in that territorial jurisdiction would be deciding as to which court would continue with the trial. Now, the next provision is section 207, which says that if a magistrate first class finds a person in his local jurisdiction who seems to have committed outside his jurisdiction, whether the place of commission was within India or outside India, then and which he cannot under the provision as we discussed herein before, that is he cannot try that offence. I mean, he does not have the territorial jurisdiction as per the provisions that we discussed today. Now, the idea here is that he though cannot try that case, but then such magistrate may inquire into the offence as if it had been committed within his own local jurisdiction, and if he finds substance, then he may compel such person to appear before him, and then if the offence is not punishable with the death or life imprisonment, then he would take a bond or bail bond for his appearance before the magistrate who has the territorial jurisdiction. So, this magistrate would be holding an inquiry and make him appear before him, and then he would send him before the magistrate which would be actually having territorial jurisdiction to try that case. Section 208 then talks about where an offence is committed outside India. It says by a citizen of India, whether on the high seas or elsewhere, as in even on foreign land or on high seas, by a person not being a citizen but on a ship or aircraft registered in India, then he may be dealt with in respect of such offence as if it had been committed at any place within India, at which he may be later found or where the offence is registered in India. Now, let us quickly come to the next chapter, that is conditions requisite for initiation of proceedings. Here, by conditions required, we mean the conditions of taking cognizance. Now, what is cognizance? Cognizance can be understood by saying that it is for the first time that the judicial court would be taking notice of the case with a purpose to proceed further, mainly to issue process against the accused. So, it is taking judicial notice of a case by a criminal court with a purpose to proceed further, mainly to call the accused in the court. And it says any magistrate of first class and any magistrate of second class specially empowered in this behalf may take cognizance of any offence upon receiving a complaint of facts, upon a police report. This is the charge sheet that we in practice say, or challan that we say, or upon information received from any person other than a police officer, or even upon his own knowledge that such offence has been committed. So, it is CPI. C for complaint, that somebody comes to the court and makes a complaint before the court. P is police report that we have seen, and I, information from any person or upon his own information that a magistrate may take cognizance. Section 211 says that if the magistrate takes cognizance under clause C, that is upon his own information, in that case, before any evidence is taken, the accused must be informed that he is entitled to get it transferred to some other magistrate. This is because there may be a feeling of biasness, the accused would be thinking that he is not being provided a fair trial. Now, making over of cases to magistrates. One says any CJM may, after taking cognizance of an offence, make over the case to any competent magistrate subordinate to him. See, the idea generally is that the court which takes cognizance would try the case. I mean, it does not happen generally that one court would be taking the cognizance and another court would be trying it. Now, this provision enables CJM as an exception to general rule that he may, after taking cognizance, sending it to any other magistrate who may be competent to try that case. Also, a magistrate first class who is specially empowered in this behalf by CJM may also act in the same manner. Cognizance of offence by court of session. It says, except as otherwise expressly provided by this Sanhita or by any other law, no court of session shall take cognizance of any offence. The idea is that this preliminary work to apply judicial mind and to proceed against the accused, call him in the court and give him the information about the case, has to be done by judicial magistrate courts. Court of session being a senior court. So, the idea is that the court of session would not take cognizance unless the case has been committed to it. Starts with this expression, except as otherwise expressly provided. Now, if you see section 222, you will find that even a court of session may take cognizance as court of original jurisdiction when it is a case of defamation of high dignitaries, President of India, Vice President of India, ministers, Prime Ministers, etc. So, if it is a case of defamation, even the session court may take direct cognizance by this, as in section 222 provides, or by any other law. So, say for example, SC/ST Act says that court of session may directly take cognizance of an offence under SC/ST Act. Next section is section 214, where it simply says that the session judges may be making over the cases to additional session judges. This is in consonance with section 8(7), which says that the sessions judge would be the administrative boss of additional sessions judges. So, on that side, as in the management of case load, etc., he would be the superior and he may send the case to additional sessions judges. Now, we have seen that the cognizance can be taken on CPI. So, whosoever would be making complaint, whosoever would be making a police, as in police, of course, police report, challan shall be filed by police only, and then it says information from any third person or himself. So, any which way it happens, 1, 2, 3, 4, any which way the court comes to hold the reign of a case, the case would start. But then section 215, 222, these provisions make inroad in this idea that the case may be taken cognizance in any which way. So, for example, 215 says that the court shall not take cognizance except on the complaint in writing of the public servant. So, that would be the only way that a case can reach to the court. It says 216 says a witness or any other person may file a complaint in relation to an offence under section 232 of BNS. 232 section is threatening any person to give false evidence. So, if this is the offence, then a witness or any other person may file a complaint in that relation. Section 217 again says no court shall take cognizance except with the previous sanction of central government. So, now this condition has been imposed that some offences like these require previous sanction of the central government or the state government, as the case may be. Similarly, 218 says that the cognizance cannot be taken against a person who has been a judge, magistrate or a public servant, except again with the previous sanction of central government or of the state government, as the case may be. Section 219 again says that the court shall not take cognizance except upon a complaint made by some person aggrieved by the offence, if these are the offences. Section 220 again says no court shall take cognizance except upon a police report. Now you see, police report of facts which constitute such offence or upon a complaint made by person aggrieved or by her father, mother, brother, sister, etc. So here police report is also given space. Section 221 says no court shall take cognizance except upon a complaint having been filed or made by the wife against the husband. This is the section. Section 67 is sexual intercourse by husband against wife during separation. Whether this separation was under a court order or even otherwise, they were living separately. So if that is the crime against the wife, then no court shall take cognizance except upon a complaint filed by the wife against the husband. So here police report will not work, challan cannot be filed, magistrate cannot take cognizance on information, etc. So only the complaint can be filed, and that too by the wife. And lastly, as we have seen, prosecution for defamation, section 222, it says if the offence is of defamation, no court shall take cognizance except upon a complaint made by some person aggrieved by the offence. And it is the second clause here that we have already discussed, that if it is defamation of president, vice president, etc., then court of session may take cognizance of such offence without the case being committed to it, and the PP would be filing the complaint. Then only the court of session would be taking the cognizance. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.